that original hearing before this executive council meeting with the PowerPoint presentation, there's a bunch of emails going up there. All right.
I remember her saying they're not the same.
Yeah, and then later on, when she sees it in the court, she finds out. Wait a minute, there were different emails. Something's wrong here.
Now look at all this stuff here, folks. Look at all this. We're going to teach you all of this here in the next half hour or so. Because we're talking Racine. Right, George?
We got a program for you.
Right. Yeah. Jim?
Yep,
Jim
you're
Spodek,
right.
Our producer, and Dr. Ken Jorgen, your host. We're going to talk about 3 different topics this morning. We're going to talk about the Sandy Weidner case, and then we're going to talk about the Navratil case with Dimple's store downtown, and then we're going to wrap it up with a little comment about Foxconn, or a few comments. Well, and actually we have one comment about Car 25 or Bell TV. We've heard that the equipment has now arrived and it hasn't been installed yet. So if you're looking to watch Car 25 or Bell TV, don't get excited. It ain't happening yet. Now,
Is that the end of it, or are we going to talk more about it later?
No, that's it. We're just going to do it. Just that quick mention there. Unless you got something you want to say.
Well, yeah, I was just going to say the reason it's not coming up is because the council is still in virtual mode and they're not meeting at City Hall. So therefore, they're not going to put up Car 25.
And nobody's interested in watching anything else other than council meetings.
Well, we can get into it if you want to, but that's all BS.
I'm just saying.
We'll dig into it at a later date.
We'll cover more later.
Yeah, we got plenty on that.
But right now we want to talk about Sandy Weidner's case, which we've talked about a couple times here recently, and we want you to consider the fact that how would you feel if you were called into a courtroom, which is, well, actually Sandy initiated this case, but let's say that you're involved in a court case and you show up and the judge tells you nobody should know that you're in court. This is so sensitive that we don't want you talking about it. We don't want anybody to know about it. This is completely sealed. This is very, very important, secret information. And you know in your heart that what you're being told should not be dispensed to anybody is just a matter of really inconsequential information. You'd probably be pretty upset by that. But that is what's going on here. Now, we're going to go into some of the details about it because there was a hearing here recently. George, this was a case where Sandy was caught, and this was at the height of the political campaign.
That's a very key element.
Sandy was running for mayor. To replace John Dickert. Corey Mason was also running for mayor. And it was very, very much up in the air. And this is when this case came out where Sandy was accused of questionable ethical behavior.
That's right. The city attorney decided to bring up a case of ethical behavior. And what it does is it gets sent to the executive committee of the Common Council. Now, the executive committee is just 4 people from the Common Council. It's the head of each one of the major committees, Finance and Personnel and DPW. But anyway, it's those 3 people plus the president. That's the 4. It was a closed meeting, but because it was of such import, the whole council went. And they started to show this slideshow, this PowerPoint presentation, this slideshow of emails. And after the first, however many would have been, there were a whole bunch of them, Sandy Weidner began to realize this is about her.
Yeah, and she had received no forewarning.
No. Just an invitation. Everybody had to come. It was a emergency meeting for the executive council that the whole council went to. And
apparently this is of such major concern that it had to be addressed by the council and then possible referral to the ethics committee.
Right.
Why was she not approached by the city attorney to say, Alderman Weidner, there's a couple of things going on here that I think concern me and I want to discuss them with you? Wasn't handled that way at all.
No.
Why no prior warnings? I mean, there was enough emails. I don't know how long it would have been.
You use the word witch hunt.
Yeah. It was just suddenly decided in the middle of a campaign. Just happened to be in the middle of a campaign, and so there they were, and Jim, and then so there that's the start of it.
Right.
And then she decides she wants the PowerPoint presentation because
Correct.
there were a lot of them there, and she just wanted she recognized them for sure, but then because of the legalities around it, she decided I better have a copy of those because those are what's going to be used against me at this impending hearing for ethical considerations and alleged violations. I should at least have that evidence.
But then magically, after the election, after it becomes publicly known that Alderman Weidner is being looked at for potential ethical violations, after that, nothing happens. The election happens, and then there's no hearing.
Yeah. Corey
It
Mason
never
won.
goes to the
Right.
ethics board.
No.
You know.
But what does happen is she decides, you know what, if you're going to put this out on me, I want to see those PowerPoint presentation. She then hires an attorney. He then asks for an open records request. Actually, being a public official, she should have just been given that information. And of course, it was denied. She then files a mandamus, which means you're going to go to court and ask the court to give me these emails. And that was done at the end of 2017. Goes to Judge Gaskergevich's court in Racine. Over a period of time, he seals the case. He seals, not only does he seal the actual courtroom, he seals all the documents within this PowerPoint. So you're not entitled to them.
He does. He goes one step further, though. He seals the existence of the case.
Exactly.
Yeah.
You were talking about, Doc, and you weren't even supposed to know the case when it was going on.
Right. So now, this is her as the plaintiff going into the court system. After a period of time, she actually gets the court, and that was after someone intervened in this and actually got the courtroom opened, so at least we could see what was going on. It goes into a number of different possibilities that she is going to get this information, but of course it doesn't. The court eventually finds her to be, doesn't give her the information and favors the city in this transaction. At that point, she mentions to the newspaper that she had a court. It was in court. They bring her back and say you can't even talk about that court, so they charge her with contempt of court and hang a $15,000 fine over her head.
Because she told somebody that her case existed. Mind that she didn't tell anything what was going on. None of the information in there.
She then files an appeal. And the appeal goes to the State Court of Appeals. The appeal comes back and says to Gaskergevich, you should release some of these emails because not all these emails are attorney-client privilege. I believe he releases about 12 of the supposedly 18. Now, these 18 were apparently given to, when Weidner went to ask for these emails, the city attorney passed out all the emails that were supposedly going to the ethics committee and were in the executive committee, and this is the email, so there's no reason Alderman Weidner has these. She said, no, these are different. These are not the ones that were in the PowerPoint program. That then takes us to the appeals court, who releases 12 of the emails, and matter of fact...
Well, they didn't even release them. What they did is they told Judge Gaskergevich to take another look.
Take a look.
We don't think that
we do
you
know
needed to
that
seal
there
this all
were,
up this way.
between George and myself, and I believe the Journal Times was in there also, that these emails were, they were nothing. They were really nothing. And the appeals court comes back within the year and says that this case should be retried. That's where we go to Kenosha.
And there was a hearing a few months ago where several people sat in. I watched the broadcast. I know you guys did,
Right.
And a few other people did. And it was rescheduled for the 7th of October, which just happened, and we finally got the order from the judge here.
Right. Now, here I want to go back to, this would be the June 30th hearing. This would have been the first hearing now that Weidner is in front of Judge Kirkman in Kenosha. Now, what we did is we have a copy of that YouTube. And I want to play that because it's interesting in this. Listen, let's just play it and we're going to dissect it a little bit.
Okay.
Is that good?
Yeah, let her rip.
It's quite unclear, Your Honor. Judge Gastrikakis went through a detailed analysis of the materials that related to the initial petition and rendered a decision with respect to privilege as to those materials. What's different with the amended petition is it includes a PowerPoint presentation which largely and completely incorporates those materials, but adds a couple slides related to what attorney-client privilege is, basically, the background for the privilege. So, in my view, from the city's view, much of what the judge has already done would apply to the amended petition other than a few frames.
Are you saying, this is my case now, are you saying I'm bound by Judge Gastrikavich's decision? I'm not.
Now, he says that Judge Gastrikakis went through a detailed examination of this material. And well, that's what Cohen was saying, the
Right.
attorney for the city. And I noticed a smile on the judge's face when he said that. Now, do you think that Gastrikakis really went through a detailed examination of all this material?
And if you listen to that closely, and I might play it a couple times because I want people to understand that he talks about there's an addition here of the PowerPoint. Now, we can dissect this a little bit, but if this PowerPoint now is being given to the Kenosha court under attorney's eyes only, but I believe this is the first time the PowerPoint has actually been able to be viewed. So Weidner, who as the plaintiff filed to look at it, has not even seen this PowerPoint presentation or her attorney. So now it's being presented to the Kenosha court under attorney's eyes only.
Yeah.
But this brings up an interesting point.
What's different with the amended petition is it includes a PowerPoint presentation which largely and completely incorporates those materials, but adds a couple slides related to what attorney-client privilege is, basically, the background for the privilege.
Yeah, now, first of all, when you're saying attorney's eyes only, there's been an additional restriction. Remember, with Gastrikakis, she wasn't allowed to tell anybody that the court case existed, wasn't allowed to tell anybody about any of the information in there. And basically, she followed that law pretty well. The only thing she did was she did tell somebody that the case existed. Never said anything was in the case. But as a result of her having told the case existed, that got perverted into she was revealing information in the case by Attorney Cohen, the person you heard talking on that video. He claimed that Sandy Weidner had revealed information in the case, which was a flat-out lie. Problem is, Kirkman believed him, and so at this point in the hearings that we're at right now, Sandy isn't even allowed to see any of the information in the case because Cohen convinced Kirkman, the judge, that she had revealed information in the case prior to that under Gastrikakis. That was a lie. She did not, but Kirkman believes that she did. So now Sandy isn't even allowed to see the information that's being presented to her attorney that the attorney needs to talk to her about.
Right, okay, here, George, I want to bring up one other part that happened in this hearing, and I'm going to play it now on here. It's Kirkman's, it says to Weidner, she objects. She objects to the fact that she can't see these emails. For the first time, she's going to actually see what the PowerPoint looked like. She objects to it and says to seal these for attorney's eyes only. He says, Your Honor, I object, she says. Kirkman, no, Miss Weidner. You have an attorney, so you don't get to talk. I'm going to mute you right now. I'm going to play that quick. So just so you see what the situation is in that courtroom.
Proceed in the same way, and at that time I could submit the PowerPoint presentation in camera for the court's review. I think it's fair to Mr. Hingston, if he's going to be responding to it, that he obviously have access to it. So it would be on an attorney's eyes only basis for him. So he can review it and present arguments, and then we'd have to submit the briefs under seal as it relates to the issues of attorney-client privilege.
Okay.
Your Honor, I object.
No, Ms.
to
Weidner,
the-
you don't get, Ms. Weidner, you have an attorney, so you don't get to talk. Okay, I'm going to mute you right now.
You see that? He actually muted her so that she couldn't say anything. She's forced to sit there and watch and grit her teeth
Well, and this was
while all this stuff is going on that she would like to have a say-so in.
and this is a virtual hearing.
Right.
This
right.
is done on Zoom.
That's right.
And one of the other things about this was that we were all expecting to be able to witness this, to view this interaction in this court, because by law we should be allowed to do that.
It's an open. It's got to be an
Open
open
court,
court. All
right.
court hearings have to be open. The Star
But-
Chamber is gone.
They shut it down.
Yeah.
They shut it
that
down.
was
Nobody was able to witness it on Zoom
Right.
or anywhere else.
Well-
Couldn't go to the court.
This was the June 30th. This one we just played was on the June 30th hearing.
Yeah.
The next one on October 7th, there was no video. There was nothing. It was basically a secret court.
Yeah.
Yeah.
There was a warning not to. No one should get the password
Right.
because it was Zoom. So
And there was no
don't give out the
YouTube
password.
access to it, anything. What's happened here is that, and really the smoking gun comes out of it. Both attorneys filed briefs with the judge, and they were back and forth redacting these briefs because there was so much, concealed information in these briefs. But what I saw on that when Cohen was talking to the judge, he said the only difference in this amendment or this complaint is that we've added the PowerPoint and a couple slides explaining what attorney-client privilege is.
What's different with the amended petition is it includes a PowerPoint presentation which largely and completely incorporates those materials, but adds a couple slides related to what attorney-client privilege is, basically the background for the privilege.
Now, I understand Jim's point is that when he makes a statement like that, it sounds like Gastrikevich never even looked at the slide.
That's my reading.
Because he said, well, the difference between these two briefs is that the slide presentation has been added. Now, there's another possibility to that.
Well, no, because I think what happened was Attorney Letney gave the judge, Gastrikevich, here are the emails. We gave them to the alderman, we gave them to Weidner, and we gave it to the judge. This is all there is, Judge. And the judge, well, I don't have to look at the PowerPoint. If Attorney Letney said this is all there is, and Attorney Cohen from Milwaukee is handling, that it's good enough for me. We're going to seal the case, seal it up. Goodbye, Miss Weidner. That's what I think happened.
And then the really peculiar thing is, now you guys know that some of the emails in there are emails to and from you
Correct.
to Alderman Weidner, and really, I know you are absolutely convinced, and I totally trust your judgment on this, they're not something that should be hidden from the public.
No.
They absolutely are not. What this case is doing, what they're trying to establish here, what Scott Letney is trying to establish is that he has absolute control over any information that passes over his desk. Regardless of how benign it is or how important it is, he is the gatekeeper of all information between you and your representatives whenever he is called in to even just take a look at something. Like if I was your alderman, you said, I need some information about a stop sign. And I go and I ask Scott Letney, what is the history on this stop sign? If he gives me an opinion, I can't share it with you.
That's exactly right.
Unless he gives me specific permission to share that information.
In other words, the alderman.
So he's trying to shut down communication and control it absolutely.
Right, information getting out to the public or wherever.
Claiming attorney-client privilege.
yeah.
Now, who's the attorney? He is. Who's the client?
It's actually the alderman.
Right.
Yeah, it's supposed to be the alderman. In other words, the attorney, the staff, is there in support of the alderman. The aldermen run the city. That's the way that's set up. And the mayor and the staff support the alderman. So they are the client. And it's like your lawyer, where you're working a regular case and you have a lawyer, and all of a sudden the lawyer tells you that you can't talk about your case unless he gives you permission. It's not the way it works. It's the other way around. The lawyer can't talk to anybody about it unless you give the lawyer permission.
Well, what's happened here, George, is that the attorneys and the city has been able to convince Kirkman in Kenosha to do exactly that.
Yeah.
And that's the part
and
that
that's
is,
the shutting down of information going out to the public, and this whole thing has gotten to be a big secret. I mean, and Sandy Weidner, all she's looking for is information about emails that she sent out.
okay. So let's get the smoking gun out.
All right.
Okay, so like I said before, the briefs were sent in from the city and then from the Weidner, and in these briefs they got redacted because there's apparently information in there that would be vital to running of the city or whatever.
Yeah, right.
But there is one in here right after the redacted, and I'm going to put it on the screen. What it is Weidner's attorney in his brief saying about the PowerPoint. This is absolutely not the case. Several items in the PowerPoint were not in the ethics board submission, and several items in the ethics board submission had not ever been presented at the executive committee meeting. That's
So in
the
other
case.
words, yeah. So in other words, emails have been shifted around between
Right.
the PowerPoint presentation and what was presented to Gasterkevich and what was presented to Kirkman. Things are getting shifted around. Things are getting put in, changed around. Some taken out. Some others put back in there.
And you don't know what it is.
Yeah.
What it is.
And that's exactly why Alderman Weidner wanted the information. She wanted to see what the heck
That
was
was
in
the
there.
thrust of the whole case.
I think that was
right there.
That's right. Was one of the problems. In other words, at that original hearing, before this executive council meeting, with the PowerPoint presentation, there's a bunch of emails going up there. All right.
I remember her saying they're
Yeah.
not the same.
Yeah, and then later on, when she's in the court, she finds out. Wait a minute. There were different emails.
Yeah.
Something's wrong here. I want to see the PowerPoint presentation, not just this.
So what
18
they've done
emails.
here, George, is they've taken Gaskergevich's court, who sealed up these emails. If he saw the PowerPoint or if he didn't see the PowerPoint, it really didn't matter. He just automatically went with the city attorney's
And
opinion.
you think he probably might not? He probably didn't even look at the PowerPoint.
I don't think the guy even looked at him. I think it was just, she's a troublemaker, and we're just going to, side with the city. Of course, she kept going. She went and went to the appeals court. The appeals court come back and says, "Hey, listen, we got a real problem here." And if you remember, it went national on those that sealed court. So now it goes to Kirkman, and what does he do? He takes it hook, line, and sinker and seals everything,
Yeah,
even
he
the
gives it
ones.
Even the ones that were turned loose
Released.
after the appeals
and not
court
only
said
that,
take
but
another look
he
at it.
seals them from Sandy now. Not just the public, from Sandy. She can't even see. It's attorney's eyes only. I mean, this is how far this has really gotten.
It's a game.
Crazy time.
And it gets around to this. It's probably. Well, I can only suppose this. It's looking like it's the shifting of emails is what they're really hiding. They're not hiding the emails anymore.
He says
It's the
right here,
shift.
they're
It's
different.
the additions and subtractions.
They're all
and-
different.
Yeah.
So when
That's
the attorney says, "Oh, these are the exact same ones that are in the PowerPoint," well, obviously there's a problem. Except for these.
What's different with the amended petition is it includes a PowerPoint presentation which largely and completely incorporates those materials, but adds a couple slides related to what attorney-client privilege is, basically, the background for the privilege.
Nobody seems to object. It's left in the brief. So there's obviously an issue here. So now everything's sealed, so Weidner's got to go to another appeal. Well,
it's all about control, folks.
It's a game.
It's all
it's a court
about
game.
control.
And the secret to control is keeping it secret. That's an essential element. Any tyranny that exists has to keep their operation away, out of sight of their constituency, of their public. Otherwise, the tyrant loses.
Okay, so one last thing here before on this case. Harry Wade, who filed originally in Gaskergevich's court to open up that court, is now back at it, and he is now filing a.
Harry Wade has been he's a activist within
what
the
is
city.
it? Something about being an overseer.
Been with Clackamas before.
Petition for supervisory writ.
So what he wants to do is skip the appeals court, because the appeals court has been playing the same judicial game as the courts in Racine, and he says, let's take it right to the Supreme Court. Now his petition for that is being I think being filed as of today is what I heard. So I mean, I give the guy credit. He put a lot of work into it. I've read it. He's complaining that the Zoom hearing on the 7th of October was not made public, which is a Supreme Court violation. He brings up a number of things that has talked about violations in that Kirkman court. I don't think Kirkman even understands what he's doing. I don't think he understands the whole case.
No, I don't think so either.
He can't understand too much if he's taking it directly from Cohen.
Yeah.
If he's always taking it from is the city's attorney, he's getting bad information. We know that. Now, the other thing that understand with Harry's case is, and correct me if I'm wrong, but he's also taking from the standpoint that he has a right as a citizen to know what's going on in the courts. That's part of the Constitution. Not only did you have a right to an open court, but the
Public has a right.
has a right to an open court also to see what's going on in these courts, and it's very essential. And particularly, who's really got to be able to get in there is the press, and that's part of the First Amendment. And then because they are the ones that have the big speakers, the loudest voices when it comes to exposing what's going on that's corrupt in government, and that's where you need a really good press. That's what the First Amendment's all about. It is not so that the press can advertise for sports or something like that, or furniture. It's so that they can keep the courts and the government honest. That is their real role in the First Amendment, not to sell newspapers and the funny papers. It's to keep the government honest, and that's what we expect the Journal-Times to be doing, and we wish they'd do a little more of it.
Well, it's a ridiculous case, folks, and there's one more thing we're going to mention here before we move on to another subject, and that is how much this is costing the taxpayers of the city of Racine. So far, we're approaching $250,000.
Yep.
We're getting close to $250,000 for bullshit.
Absolutely.
And you know how it gets solved real cheaply and real fast? Give her the stupid PowerPoint presentation.
Exactly.
Yeah.
Oh, there's nothing. Just give her the email that everybody's seen already.
Yeah.
The whole Common Council's already seen it. The Executive Council's seen it. The public a lot of the public has seen it. They just don't know which ones they've seen. But they've gone out to the public. That's why they became. So
basically, she won the case. She won the case. She actually said they were different. They are different. But the judge has denied her the payments, has denied her the right to see them, has denied her motion in the ethics committee. I mean, completely and with prejudice. I mean, it's unbelievable.
Yeah.
I think Kirkman's in for a real rude awakening. It's coming.
Well, that ain't the end of it. It's the end of it for today. I think we're going to move on to something else. Another court action. The case is the Navertills from downtown who own Dimple's LLC. It's a little shop down there. It's been there for a long time. And, people in town like it. They got little products down there that they sell that people enjoy. And they applied for some of the money, some of the relief money that was being spread around by the city to businesses that are suffering due to the restrictions of the COVID outbreak. And they were refused. They were refused any compensation. And Corey Mason made some rather unflattering remarks about Dennis Navertill in particular.
He'd been apparently bagging up virus germs and bringing them from Madison back to Racine.
He went to a demonstration up in Madison, which was basically a protest against the lockdown procedures that have been in effect. He himself was wearing a mask. He was keeping a social distance. He was there more as an observer than anything else. And as a result of him being there, Corey Mason saying that he was endangering the citizens of the city of Racine with reckless and irresponsible behavior, and we're not going to give you any money to help your business out.
You don't know how close to death you really were, folks.
So, yeah. So now they're suing the city for $50,000.
Right, for a defamation
of character.
Yeah.
And what was the city council's response?
Deny.
Go pound sand.
Yeah. Well, that's what came out of the city council. But mind you, the whole thing was held in secret. We have no idea how individual aldermen said or how they voted.
Yeah.
It might have been 8-7, might have been 15-0. We don't know. But all that secret.
It was all behind the scenes. When it went out to the common council, boom, 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 boom. No problem denied.
But that's not the end of it. It would be pretty easy if Corey Mason would have just said, well, you know what, you guys applied for $6,500. I've looked at your reply to my refusal, and quite honestly, I was a little bit unreasonable. So we're going to cut you a check, and that would be it.
No,
Makes sense.
could be that handled, you know.
I'll tell you what, I'll take you out to
$6,500.
dinner. Let's put this to bed, and let's not start any court actions. I'm sure that Dimple and Dennis are very reasonable people. They would say, you know what, okay, let bygones be bygones, and let's move forward. No, what they're going to do is cause a suit. The city attorney is then going to spend a ton of money. And this is not going to end with a defamation character. I mean, there's a lot of different things. They could be sued personally, and somebody's older, or the mayor. I mean, it's going to go beyond.
The Sandy Weidner's case is what now? 200,000
plus 200,000.
Well, we're approaching a $250,000.
Yeah.
So
it's going to be a lot more than $6,500.
You know, this is the problem. I mean, it's just that we're got to be right, and you know, my point of view, and I'm an egotistical maniac, and so my what I say is true, and I'm going to fight with your dollars to prove it.
Yeah.
I'm going to use your money against you.
Yeah. I mean, it's just ridiculous, and it should be settled, and could be handled in a very cordial way, and actually you might have to apologize, Corey, because you were absolutely wrong, but I don't see that happening. I see tax dollars being spent, but whatever.
Yeah.
So, well, we'll keep an eye on that. We'll keep you informed. The last thing we want to make a comment on is our good old friend Foxconn. What's going on out at Foxconn? Well, it turns out not that much, other than all the infrastructure work that's being done out there, which is being paid for by local taxpayers. In terms of what Foxconn itself is doing, is there any manufacturing going on? No. Are they on track to do what they originally brought up as a plan of action? No. Have they employed anybody out there? I mean, by now they should have had well over 2,000 employees. No. So Foxconn is well, let's see. The way the Wisconsin Division of Executive Budget and Finance stated is exclusive. Wisconsin report confirms Foxconn's so-called LCD factory isn't real. Who predicted that?
Yeah, I mean, we were on this thing from the day one, and we knew that this was
Well, it's questionable because it was so political. We had what 6, 7 people on that stage, and every one of them except one of them was a politician.
Yeah.
So it was and it was all the way from the president down to the state legislature. So it's like that just looked like really, really risky. If you got that much politics involved, I mean, business is what should be running it, not politicians.
So anyway, the tax benefits, the tax, what were they? What do you
tax credits?
Tax credits.
Yeah,
Were
employment
withheld by the state because Foxconn did not meet their employment targets, and so Foxconn's response is, it remains committed to Wisconsin, but WEDC's denial of subsidies threatens the good faith negotiations over a new contract.
Good faith. Well, what happened was The Verge came out and did another article on them, you know, and basically what they're saying is it was a pump and dump. They would come in, hire a bunch of employees before they would get analyzed for the tax credits, and then unload them at the end after the first
January.
Yeah. I mean, and so they got their tax credits, and now they're filing for a permit for storage. So this is what actually ignited this flurry of activity on.
No, that's
articles.
computer storage, folks. Don't think like I thought. I thought it was so people could park their extra furniture someplace. No, it's huge stashes of computer.
Well, here,
storage,
let's just do one quick thing before we close up today. But I want to just kind of bring in a little bit of like the dollars. When you talk about storage, you're going to need cooling. What do you need? You need water. Before all this started, Mount Pleasant was at about a $15 million budget. They've actually allocated, now I don't know if they've hit this number, $764 million. And what that cost was, they had 42 miles of water pipe, 26 miles of gas pipe, 28 miles of telecom wiring, plus the construction, plus the roads. So there's huge amount of tax dollars that were spent out at Foxconn. And the Foxconn, again, was supposed to pay 30 or 22 or $25 million a year in taxes. Very questionable. Apparently they've paid up to this point, but who knows where that's going to go. And now it's storage. So exactly what we said from the day one is exactly what's happening here. Now, I just want to play one clip here before we close the show on Corey Mason, who just, even after it went from a 10.5 gen plant down to a 6, he has these statements. I wonder what he says today.
Main Trail, Governor-elect Tony Evers promised to hold Foxconn accountable. So what, if anything, does a change in Madison mean for the Foxconn project? We are talking with Racine Mayor Corey Mason, who voted for Foxconn when he was a member of the State Assembly. Corey Mason, it's good to have you back with us today.
Glad to be here.
You are, as we said, one of the few Democrats who has been behind this project. Are you surprised that more Democrats have not gotten on board?
I think as time goes by and the project gets built out and people start to see it go up, I think you're going to see people change their opinions about it, not just because of the project itself, but because it's so transformative for the Racine community in southeast Wisconsin. And I think when people see those opportunities there, I think opinions will change. I mean, the proof will be in the doing. But there's been enormous work that's been done in just a year already. And I think as we see more of it, I think opinions will start to change.
Well, as time goes on, and as this thing builds up, and as the momentum builds, people are going to change their minds. They're going to realize that this is a transformational project that's going to change the whole economic complexion of this area of the state and the Midwest and America. The world is going to be a better place.
Yeah. But as soon as people see the development, then they'll change their mind.
Their
That was
wisdom.
the idea.
These guys, the politicians'
Unfortunately,
wisdom.
it's still mostly bare land out there.
Yeah. Well, so there you go. Happy Monday. We'll see you next week. We'll be back with more stories and more information. And you guys enjoy this as much as I do?
More fun, yeah.
Did you have more fun than I did?
It keeps coming.
Okay, thanks, folks. We'll see you next week.